Well, good afternoon, everybody. Nice to be with you again. And this is probably the most important topic, the hot topic that we've been facing this fall. And I sort of put the heading firm residential transactions that do not close, because that's really what we're going to be talking about. What happens when you
David,
have
I called this session "Help, my deal is falling apart."
Yeah, I sort of like that better. Like, help, my deal is falling apart, with exclamation points. That's really what we're dealing with primarily in so many cases in our office, and I know a lot of you are dealing with that too. And there's a lot of anxiety in the marketplace right now. So there's anxiety amongst you as real estate agents. There's anxiety amongst us as lawyers and our law clerks in dealing with this. There's certainly anxiety amongst buyers and sellers with what's going on. So, a real important topic, and it's current, and so I'm excited to be able to do this with you today. So let's get into it. I show you every time we do one of these things what I used to look like, and you know that our firm practices in real estate, corporate, commercial, wills, and estates. We're focusing today on residential transactions, and our offices are all open. Everybody's back in. Some are splitting their time. We're still being careful. There's still issues out there. So, and I encourage you guys to do the same. I'm still working from home a lot of times but I attend meetings and I go in once in a while and getting back to it. And it's nice to get back to a bit of a norm. I encourage all of you to check out our podcast, David and David on Real Estate. We've had some recent sessions on there where we've been talking about the very issues that I'm going to be talking to you today about for the next hour. So you can tune in these podcasts. There's like a table of contents or summary available. You can pick and choose what you want to listen to. But a lot of the stuff that we talk about in those podcasts are relevant to our discussion today. And we even had a litigation lawyer on a few podcasts ago that discussed some of these issues from a litigation point of view. So I encourage you to check that out. David and David in Real Estate. Anywhere you can listen to a podcast, you'll find it. Or you could watch it on YouTube. We have a Kormans LLP YouTube channel. So please subscribe to the YouTube channel. There's some good content on there as well. Follow us anywhere in social media. So let's get right to it, because there's a lot that I want to talk about and tell you about. So, right now, we're in an unusual market, and I've had a lot of these discussions lately. Like, what's a normal market? Does anybody really know what a normal market is? I don't think there is such a thing as a normal market. We just keep going through different variations of different types of markets. So we're coming off a market that people thought, if you've only been dealing with real estate the last few years, you may think that was a normal market where you're putting you have property goes up for sale, there's multi offers on it, and you as an agent are just really trying to figure out the price, because you can't put conditions in, you can't put anything else in, and it's just who the top bidder gets it, and it's price and closing date, and there's nothing to negotiate. Well, that market is gone. That was never what I would consider a normal market. It was an unusual market, but that was a market. Now we've got other issues that have sort of taken us off that market and are affecting whatever our current market is, however we want to define it. So here's just some of the factors that affect us and in today's market, and what we've been dealing with for it's like since the summer, really, and getting in through September and now into October. So the number one thing has been interest rates and the rise in interest rates. So that's certainly been a factor. Inflationary considerations are certainly a factor. It's affecting everybody's day-to-day lives. We're still experiencing supply chain shortages. A lot of this came out through COVID, and some of that is contributing. A lot of that's contributing to inflation and things like that, because we just can't get certain supplies for different products, and some of it relate to the real estate industry directly in terms of things that people need to build homes, finish homes, furnish homes, things like that, and other stuff, everyday things, food supplies and car parts and things like that. So there's generally a supply chain shortage that's affecting the whole economy. The war in Ukraine is still having an effect on the economy, and certainly on gas and oil prices and things like that. And all of this creates a lot of employment uncertainty, which really has a more direct effect, because when you boil a bunch of the other factors into it, people want to buy, want to move, want to take part in real estate opportunities, investment opportunities. But when they have employment uncertainty in their own workplace, there's a hesitation. So that's certainly affecting it. And some of that employment uncertainty is because of some of these other factors. Businesses have slowed down a little bit. People are a little less secure in their employment situation. The appraised values have certainly changed from what we had before, and lenders have a reluctance to lend based on a price established in a fair market process just by a negotiated agreement, purchase and sale. They want to rely more on appraised values. And we'll talk more about appraised values as I get into it, because a lot of you are experiencing that lenders are doing more than one appraisal. They're doing an appraisal at the time they're providing a consent or a conditional consent or a conditional approval rather to a loan, but then they want another appraisal done closer to the closing date, and they could get different values there. The changes to the mortgage rules certainly impacting the market as well. NRST, the non-resident speculation tax, there was an adjustment to that, an increase of from 15% to 20%, a few other changes in the rules for NRST. So that creates an effect on the market as well. The federal government is in their last budget said we're going to have a 2-year moratorium on any foreign investors buying. So that hasn't come into official law yet, but that's hanging over people, creating some uncertainty in the market. And all of this is contributed. We're now in a different market of some sort, however we're going to define it, but we're past that multi-offer market. So we're in a different market. There's different price considerations. There's different pressures on us. There's different timing, different expectations. We're back into a market where conditions can be accepted on agreements and purchase and sale and negotiated conditions. And through all of this, and this is affecting, it's not just the local market, it's affecting the market across Canada. And but there's still a uniqueness. I always talk about this. There's still a uniqueness to the GTA market. So even when things are really bad in other places of Canada, even when it's really bad in other places in Ontario, the GTA market is still an island unto its own. And no matter what affects the market, there's still a lot of people that just want to live and stay in the greater GTA, Greater Toronto area, and that keeps expanding, but it sort of keeps us a little bit insulated in our own market from other markets. So even when all these factors are there, we still generally have a pretty good market. So bottom line, I wouldn't give up hope on anything. I know things are a little quieter for everybody right now, and you're feeling it. Markets are cyclical. This is not going to last. Whatever this is not going to last. There is going to be opportunities. So stay positive, keep working hard, look for the opportunities, look to how you're going to make a difference to your client. So those are some of the factors. Now we're dealing with some issues right now that are actually preventing closings from happening, where people can't close and have to get out of transactions or do not close, or they're just delaying closings. And we're dealing with that on a daily basis with a number of transactions. It's still, at the end of the day, a relatively small percentage of transactions that get affected by this, but everybody wants to talk about it. And we're experiencing that at our end, even transactions where we have absolutely no issues apparent, and we're just moving towards a regular closing in the normal circumstances. We have clients contacting us and saying, well, what happens if my buyer can't close? What happens if they don't get their mortgage funds? I'm reading everything in the paper. I'm hearing everything on the news. I understand there's all these things going on in the market. So what happens? What if? And everybody wants to have those conversations. And I'm sure a lot of you are going through that as well. So it's important for you to understand what is happening on the situations where we're really dealing with a situation, so you can answer these questions as well. And like I said before, there's just all this anxiety in the market because anybody that doesn't close or is running into problems because they have a delayed closing, These are the stories that get out there, and everybody that has a normal deal closing in the normal course is worried that what if theirs is next and what happens, and they want to have those types of conversations. So here's some of the issues that are impacting us. There's the change in circumstances, like I mentioned earlier. People may not have security of their employment. They might be in a firm deal. All of a sudden, one of the spouses or something, might lose a job, things like that. Purchasers get cold feet. There's this concept of buyer's remorse out there, changing your mind. I can tell you for certainty, there is no concept of or legal right to change your mind or have buyer's remorse or have cold feet. It does not exist in law, except in one specific type of transaction. If you're buying a new condo transaction from a builder, and you enter into an agreement of purchase and sale, under the Condominium Act, there is a 10-day cooling off period. So a buyer has that 10 days to get out of a deal for whatever reason. They don't have to justify it. They can get out for whatever reason. If they have cold feet, in that circumstance, they have a right to get out. Other than that, new construction condo, there is no such concept. You can't have cold feet as a buyer. You can't get cold feet as a seller. You can't have buyer's remorse. You can't have seller's remorse. Okay, those don't exist. People have them. They don't have a legal right to have them, is what I'm saying. Okay, so we're going to have to deal with that if someone does say, hey, I entered into a deal, but I don't like my deal. And we get that all the time. Seller sold. A day later, they get a better offer. Hey, can I get out of my deal? Okay, so the short answer is no if it's a firm deal. But we're always going to take a look at, because maybe it's not completely a firm deal, or maybe there's an opportunity. But you can't just change your mind, okay, and say, I got a better deal, so I want to change your mind. Same thing on the buyer's side. You can't have cold feet and get out of a binding agreement. Now, we're always going to look, is it binding? So we're going to talk about some of that, okay? So other issues that are affecting the interest rate hikes, obviously, are really affecting things. Purchasers are unable to qualify for a mortgage. And a lot of these purchasers had a pre-approval. Oh, you're pre-approved to buy a house up to $1 million. We'll give you a loan up to $700,000. So they get pre-approval, but that's subject to certain conditions. And then when they actually have a firm deal on something, and the buyer and the lender takes a look at it, they say, hey, yeah, you paid $1 million for this, but our appraisal says it's only worth $950. So we're not giving you as much money as you thought you were going to get. You're going to be $50,000 short in what we're going to lend to you. So, and all of a sudden they're scrambling to make up that difference. So it's issues like that that are really affecting these types of closings. Appraised values come in differently than the purchase price. Okay. So some of the issues we deal with is just timing issues, especially if people buying and selling on the same day. We do that all the time. There's no problem with buying and selling on the same day. Okay. But if, usually we need to sell, we need the proceeds from the sale in order to complete the buy. A lot of times there's a chain of transactions that have to close. So if something happens somewhere in the chain, it might be in our client's deal, or it might be in somebody else's deal. It might be our buyer has to sell their property, and their buyer has a problem. So we do run into these issues, okay? Because we need funds in time to close a transaction. We have to close, the registry office closes at 5 o'clock. We got to get registered by 5 o'clock. We have an ability to close an escrow up till 6 o'clock. Sometimes we just run into a timing issue where we can't get the funds. We've now closed a sale at 4:59. We have the funds, but we can't get it to complete the purchase transaction. We can't get it to the seller's lawyer in time. So sometimes we just need an extension for that. So if we can get the funds to them by 6 o'clock, we usually have an ability to close an escrow and complete it on an escrow closing. If we don't, we're looking for an extension, and the buyer's not going to be allowed into the property, and they need a place to stay overnight and somewhere to store their belongings. So you can be offering your place if you want. We generally don't offer our places, but something you got to deal with. Okay. So, generally, a buyer, if they're buying and selling, they need the funds from their sale in order to complete a purchase. So that's an issue that we're dealing with right now. Sometimes we have title issues that we're dealing with. There's easements, there's pending litigation, there's defects on title, there's liens like construction liens. property might still be in registry system, being converted to the land title system. Those are all issues that we deal with in the normal course. These aren't issues that are just coming up more today than they would in any market. These are the type of issues that we deal with all the time, which is why we search title and why we send requisition letters to get title cleaned up, etc. But there's still issues that affect any transaction from closing. So I wanted to include this in this presentation as well. And then there's inspection conditions. There's inspections that people have, that they're entitled to certain inspections, and that could lead to issues that the buyer might have, the lender might have. So we got to deal with those. And those are like physical type of defects and things like that that affect closing. So here's a really important concept that you've got to make sure that you understand and that you convey this to your clients, okay? Every transaction, standard form agreement of purchase and sale, in the fine print that most of us ignore all the time because we're busy just filling in the blanks and adding schedules with provisions in it. But in paragraph 20 of the standard agreement of purchase and sale, there's a paragraph that basically says that time is of the essence. Okay, time is of the essence. So what that means is there's certain clauses in a standard agreement purchase sale that deal with time. The irrevocable date. Okay, this is irrevocable by the buyer or the seller until 5 p.m. on October 13th, 2022. Completion date. This transaction is going to be completed on October 13, 2022. The requisition date. You have the buyer has until October 13, 2022, if that's the date that's filled in the blank, to do your title search and to make any requisitions if there's any title problems. Or if you're putting in any conditions on your agreement and you've got, this is conditional on inspection, or conditional upon reviewing a status certificate, or conditional on getting financing until 5 p.m. or whatever time you put in there on October 13, 2022. You're filling in those dates, and not just a date, but sometimes a specific time within those dates. So the point is, those aren't suggestions, okay? Those are an important, essential part of every contract for an agreement of purchase and sale. And paragraph 20 says time is of the essence, which means that you have to comply with those provisions by the time specified in those clauses. You can't miss it. Okay, if it's supposed to close on October 13th, you don't have the right to close on October 14th. If you don't close on October 13th, you're in breach of the contract. Okay, if you haven't given your title requisitions by the time and date specified, and you give them after that, the seller doesn't have to answer those requisitions, and the buyer's going to have to take title subject to whatever defects are there. Okay, if the condition dates are missed, they're missed. The important thing is, don't ignore those provisions. They're important. Time is of the essence. So if somebody can't close on time and they need an extension, they don't have the right to have an extension. There's no unilateral right to an extension. If the transaction says it closes on October 13, 2022, both parties have to close at that date. So if a party runs into a problem and needs an extension, they have to negotiate for that extension. And if it's the buyer asking, the seller has the right to say no. So what happens if they can't close? The breach of contract. Okay, buyer can't close for whatever reason. They can't get their financing together. Their mortgage lender's not ready, or the mortgage lenders said, yeah, we're ready, but we did an appraisal and we can't give you as much money as we thought we were going to give. And now the buyer is scrambling to get their money. And maybe the buyer can get the additional money, make up the difference, but they can't do it on October 13th. They need another day. They need a few more days, or their mortgage just fell apart because of it. And they have no other way to get the money. So they need to go to a different lender, or they got to get another institutional lender. Maybe they have to go to a private lender, and they need a week, or they need a couple weeks to be able to close the transaction. So these are the type of issues we're dealing with. So bottom line is, if the buyer can't close on time, the buyer is going to be in breach of the agreement of purchase and sale. So there's two terms that you might hear sometimes. One is a breach and one is an anticipatory breach. So if I get a letter from another lawyer a few days, let's say a few days before the closing, or even the day of closing, saying, and we're acting for the seller, and the buyer's lawyer says, my client's mortgage financing just fell through. We can't close on October 13th. We need another week to extend the closing to sort this out. So if the buyer's lawyer is telling me before our closing, we can't close, that's an anticipatory breach. I can write him back and said, your client is in breach. We don't have to wait to the closing date. You're telling us today that he won't be able to close on the closing date. So he's going to be breaching. He won't be able to close on the closing date. So we can start taking action and respond to that because they're telling us in advance that they cannot close on time. Okay. Now, if the lawyer just said, we might not be able to close on the closing date, we're working on it, we can't take that position yet. It's only when we get to the closing date that they're either going to close or they're not going to close. So if they don't close on the closing date, then they are in breach of their contract. So that's sort of the difference, the nuances. So if they're telling us definitively in advance that they're not going to be closing, that's an anticipatory breach. We can start taking action and protecting our client at that point in time. Specific performance is one of the remedies that's available to parties on transactions. And that's the process is going to court and getting a court order from a judge requiring the other party to close. Okay. Now, a seller is never going to get a specific performance remedy from a buyer. If a buyer can't close, buyer can't close. Seller's got remedies that we'll talk about. Okay. They can say you're in default. They're going to sell the property to somebody else, keep the deposit, sue them, etc. So specific performance is more if for some reason a seller doesn't close and the buyer's trying to insist on the seller closing, and they'd have to convince a judge that there's something special about that property that the buyer can't be compensated in damages, and they want an order from a judge to force the seller to close. Very rare type of remedy to get, but it's just something that's out there. So I just wanted to mention it. So I'm going to focus more on buyers not closing. What are the seller's rights and remedies, and what happens to the buyer? So the first thing is the deposit. Buyer doesn't close, they're not going to get their deposit back. Okay. And again, we're assuming here the seller's done everything right. Seller's ready, willing, able to close the transaction. Documents are signed. They're all ready. Okay. No issues on the seller's side. Buyer can't close for one of these factors, any of them. So what happens? A buyer can't close. The first thing that's going to happen is they're going to lose their deposit. Okay. They're never going to see their deposit again. They're not entitled to it. They're never going to get it back. The brokerage that's holding it at some point in time is going to give that money to the seller. Okay. Now, it may not happen on the day of closing. Sometimes brokerages want releases to be signed. We're going to talk about that. At the end of the day, at some point in time, that deposit money is going to go to the seller. It's never going to go back to the buyer unless the seller agrees to give it back or part of it back as part of a negotiated settlement. But they certainly don't have to. Okay. Buyer has no right to get that back. Okay. So that's the first thing. Deposit's gone. The second thing is the defaulting buyer may be responsible to pay other damages to the seller. So what we do if a buyer defaults, we send a letter to the other lawyer that basically says you're in default, whether it's a breach or an anticipatory breach, it's the same thing. We point out what their breach is. They're not in a position to close. You're in default. We're keeping your client's deposit. Say goodbye to that. They're never going to see that again. But we're also reserving the seller's rights to hold the buyer responsible for any other damages and costs, expenses, etc., incurred by the seller because of that breach. And we don't know what those damages are going to be at that point in time. So that's why we're just reserving the rights to claim those for whatever they might be. So there's a list here of some of the potential damages that we could be seeking to recover. And the first one is sort of the most obvious one. There might be a difference in the purchase price. We were supposed to sell to that buyer for $1 million, markets change, we're putting it back in the market, and we only get $900,000. So we have $100,000 difference in purchase price. So obviously we want to claim that difference in purchase price. We were supposed to close October 13th. Now we're reselling the property and somebody's going to buy it, and maybe they're closing on December 13th. So we have to carry the property for 2 more months. So we want to claim that against the defaulting buyer. The carrying costs for utilities, insurance, property taxes, common expenses, if it was a condominium. Okay. We're expecting to close today and get the money today. And from the proceeds, we would have paid out mortgages and bridge loans. So we want to claim interest and those costs because we can't pay it out today. We're going to be paying it down the road at some point in time. So we don't know what that's going to amount to, but we want to make sure we're reserving our rights for that. Maybe there's some lost opportunities that we can claim for. We were expecting the money today, and we were supposed to be doing something with that money, whether it's buying another piece of real estate or some other investment opportunity, and that might be gone. So maybe there's a claim that we can make for lost opportunities, okay, through the litigation process. The seller is going to incur additional legal fees for dealing with that. So we want to make sure we're claiming that as potential damages. There might be a difference in real estate commissions or extra real estate commissions involved for reselling the property to someone down the road. So a seller might be able to claim for that. So we want to reserve all those rights because we don't know what those damages are actually going to be. Now, there's another concept at law that you have to be aware of, and it's called mitigation of damages. So yes, we're going to reserve the right to claim for all these damages, but a seller has to act reasonably in accumulating those damages. So they have an obligation, if this deal fell apart and they're going to resell the property to somebody else, they can't just accept the first offer that comes in, and it was $900,000, so we got $100,000 shortfall, but don't worry, I can claim that against my defaulting buyer. You can't just do that. You have to go through a process first where you expose the property to the fair market. Okay, you got to put it back on, you got to list it, make sure it's out there in a multiple listing again, so it's exposed for a period of time, and then see what offers come in. And if it turns out the best offer you got was $900,000 and you had $100,000 shortfall, that's no problem. Okay, but if an argument can be made by the defaulting buyer when this goes to litigation that you didn't take proper steps to reasonably expose the property and try and get the best fair market price, that gives them a defense, because you can't just pile up these damages without taking some reasonable steps to minimize them as much as reasonably possible. And that's what a judge would ultimately look at if this does go to litigation. Okay, but if the seller took those steps and was acting reasonably and exposed the property and sold it for the best price he could get, and it happened to be a shortfall and they couldn't close quickly and the closing had to be 2 months later and there's all these carrying costs, etc., there's no problem with the seller making those claims against a buyer, because they would have made those attempts to mitigate their damages. Okay, now a question that comes up all the time is, can the seller keep the deposit? Because maybe the deposit was $100,000 and then still claim for all these damages, $100,000 difference in purchase price, and maybe all these carrying costs amounted to another $25,000 or something. Can they claim it all? And the short answer is yes. Okay, it's two separate claims. They have the right to keep the deposit and they have the right to make this claim for damages. So they could have both. Okay, so having said that, if this does go to litigation, a judge does have a discretion to say, you know what, we want to make sure we keep the seller whole. We don't want the seller to lose any money. So we want to make sure they have enough money to cover all these differences in costs and all their damages. But we also don't necessarily want to give the seller a windfall. So maybe he's got $100,000 deposit and he's got another $125,000 in damages. So if we cover them for all the damages, all the costs he really incurred, if he keeps the deposit too, he's $100,000 ahead of the game. It's a windfall to the seller. Now, at law, they're entitled to that, but a judge does have some discretion to say, this isn't really fair to the buyer, and I'm not going to let them keep it all, and we're going to offset some of the damages against the deposit that's already being held, and we're not going to give them the whole thing. But if I'm a seller, I'm certainly making a claim for it all. Okay. And it's important to know that they have the right to that, and it's a judge's discretion to say, I'm going to, give the buyer a bit of a break here. And the reason you have to know that is because a lot of times this doesn't go through the whole litigation process, but we use the same principles to negotiate for certain settlements and say, look, seller, there's going to be a windfall here. You might be able to keep it all if this all goes to court. We'll find out 2 years from now when we get a judgment from a judge. But if we don't want to go through that whole process, and we offer some money back to the buyer, and we could just settle and sign releases and be done with it, sometimes that's a good solution for everybody, because the litigation process sucks, for lack of a better term. Okay, so that leads me into the next thing, which is the release of the deposit. Now, the brokers are holding the deposit. Generally, brokerages don't want to give the deposit out unless they've got a mutual release signed, or there's a clear direction from both the seller and the buyer where they're both agreeing in writing that the deposit can be released to the seller. Okay. Now, if we're on the side of a seller who's an innocent seller and there's a defaulting buyer, we do not want that seller to sign a mutual release. Okay, as much as that seller wants that deposit money released to them, if they sign a mutual release, it's basically saying, in exchange for the buyer agreeing that the brokerage will give me the deposit money, I'm releasing everybody, the buyer, the brokers, the agents, everybody, from any further obligations. So that defeats the seller's rights to claim any further damages. So we have to be very careful anytime there is this default and a breach, that somebody we don't want a seller signing a mutual release unless there's a negotiated position, because they're doing that in exchange for something else. We don't want them to give up their rights to that. So sometimes if the defaulting buyer is not prepared to sign a direction allowing the brokerage to give the money to the seller, the money's going to just sit there in the brokerage's trust account, until there's a court order telling what to do with it, or until the parties agree in writing and both direct the brokerage to give the money to the seller, or give part of it to the seller, part of it to the buyer, whatever was negotiated. Okay, so sometimes the money's just going to sit there for a period of time until that happens, which is why I say eventually the seller's going to end up with that deposit money unless they negotiate something different. But there might be a process, and it might take a little time to get it, because they might have to go to court to get a court order directing the brokerage to release that money to the seller. Whatever we do here, when you're on the agents, you as agents are on the buyer side, seller side, we as lawyers acting on real estate transactions, it's always better to avoid litigation if there's an opportunity to avoid litigation. So we have to understand these legal principles. We have to understand the process, but it's always better for us to try and negotiate some sort of settlement, work something out if we can. If we can't, we got to bring in a litigation lawyer. And they're not the nice, friendly, jovial real estate lawyers that I fancy myself as, and other people that are doing transactional work. They have a whole different attitude towards the law. They're totally adversarial. They're going to try and make the life miserable for the other party and the other party's lawyer, and bring motions and delay tactics, and the costs just keep piling up. And if it's going to go to litigation, the litigation lawyer is going to want a retainer up front. Real estate lawyers generally don't ask for retainers to close a real estate transaction. Okay. But a litigation lawyer, and the reason is because they normally close and we're going to get paid on closing. But a litigation lawyer is always asking for retainer, and they're getting involved in things like this. Retainers are usually going to be a minimum $5,000 to $10,000. The legal process could be $50,000, $100,000 to take this right through trials, to go through these issues. So there's lots of incentive along the way, even for an innocent seller to decide, I want to get some certainty here, not take my chances, not have to pay my litigation lawyer to go through this and fight for me all the way through with the hopes that I'll recover all of that and all those costs. So there's incentive there for even a totally innocent seller at some point, and a few different points actually, to say, you know what, let's settling this thing one way or another is really a good thing. I want to make sure all my damages are covered and my costs are covered. Maybe I get a bit of a windfall, maybe I don't, but I want to get some certainty and it's worthwhile settling as opposed to going through a litigation process. Okay, and a litigation process, it's going to take a year or two till you actually get right through a trial. Very expensive, time consuming. If there's ways to avoid it, let's avoid it. So I want to go through a series of options, strategies and options that should be considered. Okay. First one is, there's a breach of contract. Terminate. This is what we've been talking about. We could terminate. You're in breach. We're terminating. We're going to relist it, sell to somebody else, sue you for damages. Okay. That's one option that we've talked about. Another option is, well, maybe they do have an ability to close. They just can't close today. Maybe they need an extension. Maybe it's reasonable to extend first and give them a little bit of rope, see if they can close. Maybe it's a few days, maybe it's a week, maybe it's a couple of weeks. Let's negotiate terms of extensions, give this buyer a chance if they're showing an ability that they can close. Better do that than go through the other process. So let's explore that. So if we're going to extend, there's a bunch of things that we want to extend on certain terms and conditions. So I've got a list here of some of the things that we want to consider. Maybe we want to get an additional deposit. Maybe the deposit that was originally paid isn't that significant, and the buyer might be prepared to walk away from that. But if we get a further deposit, we really got the hook in there deep, and they're going to try everything they can to close on the extended closing date, and let them put their money where their mouth is and put up some additional money to close. Okay, because whatever we got as a deposit isn't usually all the money that the buyer has available to put in, because they're not getting 100% financing from a lender. So there's always that difference between the deposit they put up and the amount of the mortgage that they're trying to get, that they've got money available, and they would have given that to us on October 13th. So why not still give that to us as additional deposit? And that could be characterized as a non-refundable deposit. So again, buyer's never going to get it back, but let's get some money in so they show some good faith and they put their money where their mouth is, saying, yeah, I can close in a week. Okay, prove it, that you're really serious. So we're not selling to somebody else. We're prepared to hang around for a week, put up an additional deposit. Okay. Will the buyer tell your brokerage who's holding the deposit money to immediately release that? Maybe today, or maybe it's if they don't close on the extended closing date, the buyer will sign a direction authorizing the brokerage to immediately release that deposit money to the seller. So we try and negotiate that. We want to get certain costs covered. So we want to get interest on any mortgages or bridge loans covered. We were expecting to get the money today, and we're not going to get the money for another week. So we want to get interest on the balance due on closing. Okay, we may incur some storage or rental costs. We may want to get that covered. Okay, now we might extend for a week. If the buyer is able to close earlier, maybe we're all happy to close earlier if they're in a position to close earlier. We don't want them to raise any title issues. So we want them to waive any and all requisitions, so they confirm today that they have no title issues, so we don't get to the extended closing date a week from now and all of a sudden they say, oh, there's a title problem and we can't close because of a title problem. So we want to get them to waive if we can. We're negotiating these terms of extension. So we like the buyer to pay the seller's costs for legal fees for negotiating this extension. And the last thing that we always want to include in any of these negotiations is that all other terms and conditions of the agreement of purchase and sale to remain the same. And again, that phrase, time to remain of the essence. Because if we're agreeing to an extension to October 20th, that's now the new closing date. So we want to affirm again that time is of the essence. October 20th is not a suggestion. That's the date that the transaction now has to close. So we always want to put that in there. So I can tell you, we've got these list of things here for you to see, but I encourage you, if you're in any situation with a defaulting buyer, okay, and you're on the seller side or you're on the buyer side, these things are something that should not be negotiated by you as an agent as an amendment. The lawyers really should be involved in this negotiation. Okay. Now we need your assistance as an agent to help us determine, whatever we can, like which of this list of terms we should be including. And sometimes you can give us information about whether there's a chain of transactions that are getting held up here. There might be other costs that be incurred here. So you're playing an important role, but I encourage you to have the lawyers involved should be negotiating these things with your assistants. Another strategy is a termination and extension. And this is sort of a combination. So sometimes we have to take a position that you're in default, we're terminating you. Okay, buyer, you're terminated. We're going to sue you, reserving our rights to sue you for damages. We're going to put it back on the market and sell to somebody else, reserving our rights. We're keeping your deposit. Okay, but sometimes we say without prejudice to that, if you can get your act together and agree to certain terms, we're still prepared to extend and give you a chance as long as you can close. So it's sort of a combination of the two things. We're terminating, but we're agreeing. If you agree to our list of terms and conditions for an extension, then we will give you an extension on certain terms. And sometimes we're doing that just to get their attention and make sure they understand that they're in default. We're terminating and then extending. Okay. Now, a price reduction as a strategy and option is something that I wouldn't tell anybody to dismiss out of hand. Even though if you have an innocent seller, sold it for a good fair market value at the time it was negotiated, and you worked hard as an agent to get them that price, now you got a buyer that's in trouble because the appraised value came in significantly lower. They've tried, they can't make up their shortfall, and the buyer is saying, hey, seller, we're doing everything we can. We tried here. We're trying to get financing. We can't. We have no more friends and relatives to borrow and beg from. We got a shortfall. We're $50,000 short. Will you agree to an amendment and sell it to us for $50,000 less so we can close? So seller immediately is going to say, like, screw you, no chance. We got a firm agreement. We're going to sue your pants off. We got all these rights. My agent explained all these rights to me. My lawyer, David, explained all these rights to me. I don't have to do any of that. And you don't. But we look for practical solutions too. And it might be more practical in certain circumstances for a seller to sell for a lower price and if they can close right then and sell for a lower price, that might be a good option for a seller. Okay. And that's where you come in and play an important part in that decision. Because if you go back to the seller and say, look, if we go back to the market right now, we're not likely to sell it for even $50,000 less than before. It's probably $100,000 less. Or maybe it's going to sit on the market for a long time. We don't know. And yes, you have a right to try and make all these claims against that buyer, but we have no certainty whether you're going to be able to recover it from the buyer, whether the buyer is going to have funds to pay you for all these damages. And there's uncertainty with the timing and everything else. And you need the money because you got a purchase closing and you need the money for something else. So it might just be a really good option for a seller to consider taking a bit of a haircut and getting this transaction closed with that buyer. Okay. It depends on the facts, depends on the circumstances. All I'm saying is don't dismiss it. Don't let your seller just dismiss it outright without giving it some thought and consideration and doing the math and trying to figure out what the best solution would be. So that's certainly one of the options that has to be considered. Another option, another thing that I encourage everybody to consider is getting bridge loans. Okay. Even if you have a purchase and sale closing the same day, I always tell people to consider if you can get a bridge loan available to you. If your transactions close and you don't need the bridge loan, no problem. You're not paying anything to your lender. The cost of a bridge loan is minimal. Administration fees, interest rates, even though they've gone up, they're still at relatively low levels. If someone has to have a bridge loan for a week or two at current interest rates, it doesn't amount to a lot of money. So if they have that available to them, so if their buyer can't close, they're buying and selling, and they got a buyer that can't close on time and needs an extension for a week or two or more, they still can get their purchase transaction closed because they've arranged for a bridge financing. So they can still get closed. And all a bridge loan is, it's a short-term loan that bridges the gap between someone's purchase and their sale. So if they're closing on their purchase first and the sale closed later, they need a bridge loan to get their purchase closed. And then when they close their sale, the bridge loan is paid out of the proceeds from the sale transaction. Okay. I encourage you to tell all your clients, arrange for a bridge loan as much as they can get, just in case they need it. Okay. And if they don't use it, the lenders don't charge them anything for it. So and even if they did charge them an administration fee of a couple $100, it's great insurance. It's worth doing. Now, if a bridge loan, if the gap that they're filling in is generally a relatively short period of time, the lender doesn't need security for this. It's usually a bridge loan. All they get is a promissory note signed by the borrower, and they get an undertaking from the lawyer acting on the sale. That's like it'll be from my firm saying, yeah, Kormans is acting on the sale that's closing in 2 weeks. And we agree that from the sale proceeds, we'll pay off the bridge loan. So that's generally what a lender needs. The two things: a promissory note, undertaking from the solicitor. If the bridge loan is going to be for a more significant period of time, sometimes a lender says we need a little more security, and we may want a security by way of a mortgage. And the mortgage might be on the property that they're buying. It might be a mortgage on the property that they're selling. It might be a mortgage on both properties. Sometimes the lender will say, we want those mortgages signed as security, but don't register them. And we'll only register them if a transaction does not close. We can register them in the future. Sometimes they say, go ahead and register them. So if we're in that scenario, there's some additional costs in providing security to a lender and drafting mortgages and maybe registering and then discharging them, but it's still worth it. It's still worth doing and considering. So I encourage all of you to tell every single client to see if they can get a bridge loan if possible. Now, another potential strategy and option is getting a seller to take back a mortgage. Okay, so here buyers financing has fallen through, or they're not getting enough financing. So one way to get the transaction closed is by the seller financing and the seller taking back a mortgage. Now, if there is a first mortgage and there's a gap, there's a shortfall because the buyer's not getting enough money to close the transaction, it becomes an issue these days about getting a vendor take back mortgage or secondary mortgage, because most mortgage lenders these days have a specific provision and condition in their mortgage that doesn't permit a second mortgage to go on at the time of closing. So if that's in there, you're not going to be able to get a mortgage, a second mortgage by a vendor. Now, if the financing completely fell apart and the seller is prepared to provide a first mortgage, then that's something that should be considered. Maybe the seller provides a temporary, or not a temporary, but a short-term mortgage back in order to get the transaction closed. And then that gives the buyer some time to find some financing to pay out the vendor. And if the sellers go on that route, obviously, the interest rate is going to be pretty significant, and there has to be a specific time frame. So we don't see it a lot right now. We used to see it more before lenders all switched to requiring that their first mortgages be first mortgages, and they're not permitting secondary financing behind them. But anyways, it's something I throw out there because in certain facts, certain circumstances, it might be a way to get a transaction closed with a seller take back mortgage. Now, revival is another strategy option I want to mention. Sometimes we've terminated. Okay, we're relisting, we're going back on the market, and all of a sudden the defaulting buyer gets their act together, gets their financing together. They come back and say, hey, We got our mortgage commitment. We're prepared. Can we go back and sign and get our deal closed? So we have to go through a bit of a process because the agreement is over. The agreement was terminated. So now we have to revive the agreement. And there has to be something in writing between the parties. And again, it shouldn't be done through the agents. The lawyers should be involved in this to properly revive an agreement. And there may be, it might be reviving it to say we're using the old agreement, and maybe we're just making certain amendments to it because we obviously missed certain dates. So we've got to amend it. We're now closing on October 20th or whatever the date's going to be. And there might be there's additional terms that are negotiated, but we're going to revive an agreement that already died. So that's a possibility. Okay. Now, one thing I want to mention to you, I've talked about sellers' rights, buyers in default. We've got all these rights as a seller. The law has evolved a little bit in recent times, and a lot of it's through COVID. And we're going to see that because a whole bunch of cases came up through COVID, still in the courts, and now in the market that we're going through, where we got a bunch of innocent people that really want to close. Facts, circumstances change, and they can't close, and they're stuck. And the seller's got all the rights to hammer them on these things. But there is a concept in law that of good faith and having clean hands. So clean hands is if the seller does anything that they shouldn't have done, or if they're not in a position to close, they're going to lose some of those rights they otherwise would have had. So the seller has to be an innocent party in order to really enforce all these rights. And a seller has to act in good faith, as does a buyer. Okay. So if we're in a scenario where a buyer says, I can't close today, but I really can close tomorrow. And I can show you, here's the evidence. My mortgage lender is confirming we can close tomorrow. We need 1 day. And the seller says, screw you, buyer. I know my rights. I'm terminating you. I'm keeping your deposit and blah, blah, blah. So he's not necessarily acting in good faith. He hasn't gone through a process of trying to find a way to close the transaction. So a buyer might be able to defend his position by saying, hey, the seller didn't act in good faith. Just tried to hammer us. We showed them we had an ability to close. We were asking for reasonable terms. We were covering all the costs and expenses. And the seller just tried to hammer us because he was not acting in good faith. So those type of concepts come in as well. So I want to finish off with just giving you some tips on how we avoid these breaches of contract. And I'm going to try and get this done in the next 5 minutes. So first thing to tell you, we need to draft better agreements. We've got to make sure our agreements are all drafted properly. And as like I mentioned at the outset, you as agents are going to be in this market are drafting and negotiating agreements differently than you were in the multi-offer type of market. Okay, conditions are now acceptable. We're not having offers out there very often these days that have no conditions in them. We got to draft them carefully. You've got to draft the conditions properly. Okay, make sure the time frames are met, etc. Okay, make sure that you're asking all the right questions regarding the property. Leave no stone unturned, whether you're on the buyer's side or the seller's side. Make sure you know your client. You understand their overall situation. You understand where all the potential financing is coming from. You understand if there's a chain of closings that have to happen. You understand whether they can get their financing, whether they can get bridge loans, etc. Okay, we want to make sure that we're dotting all the I's and crossing all the T's in the process. So if there's certain things that have to be delivered, surveys, leases, other reports, make sure things are delivered on time. Time is of the essence. Don't miss any of those deadlines. Okay, make sure the conditions are all met on time. Time is of the essence. I keep emphasizing that point. The main thing we're dealing with these days, I mentioned earlier, is all the mortgage issues. Okay, so we want to try and get ahead of that and try and eliminate as much of those mortgage issues if we can. Make sure you have a really good mortgage broker on your team. Okay, if you're the buyer says, oh, I got a guy, ask who the guy is, check it out, find out, make sure you might have a better guy that they should be dealing with. Okay. Just like who's your lawyer acting? Well, I got somebody else that maybe you should be dealing with. I got a better lawyer. Okay. You got to make sure you've got a proper team in place to deal with potential issues that come up. Make sure the buyer has a proper pre-approval before the offers are coming in. Pre-approvals that are subject to a whole laundry list of conditions are a lot of times not worth the paper they're written on. So it's not enough for your buyer to say, oh, I've got a pre-approval. You got to take a look at it. If you're not sure, get the lawyer involved and make sure you got a proper pre-approval. Okay. Understand your client and what they can afford and where the money is coming from. Okay. Make sure you're confirming with the buyer appraisal results. On these mortgage approvals, one of the things you really got to steer clear of is the opportunity for a lender to do a secondary appraisal. Sometimes they're doing an appraisal when you're doing the deal. The deal's closing 2 months later. And in the approval, it says that the lender has the right to do another appraisal prior to closing. And that's what we're running into these problems these days, because they go and do that appraisal, secondary appraisal 2 months later, and the values have gone down. And now we're a day or two before closing, and their lender says, sorry, we're not giving you, you bought it for $1 million. We think it's worth 900,000 today. So we're only going to give you 70% of 900,000 instead of 70% of $1 million. There's a shortfall. You got a day to deal with it. So we want to steer clear of mortgage approvals that have these secondary appraisals in it. So it doesn't give us time to deal with it if we can. So be on top of that. Bridge loan, I mentioned before. Okay, important to look for the opportunity to see if there's a bridge loan. You need to get proper support from the lawyers on the transaction, whether you're on the buyer side or on the seller side. Okay, get support. Your lawyers should be supporting you in drafting proper conditions and looking at these clauses. If you have any questions about it, that's the time to get the lawyer involved. Find out who the buyer's lawyer is, who they want to use. Say, well, first question would be, well, why aren't you using Kormans? But we know we can't do all the transactions, and there are other good lawyers out there too. But there's also a lot of lousy lawyers out there. So pay attention to it. There's good brokers, there's lousy brokers, and everything in between. There's good lawyers, there's lousy lawyers, and everything in between. There's good agents, there's bad agents, and everything in between. Okay, so we want good teams. We need good teams, especially in these times to deal through these situations. So make sure you're getting support from lawyers. Make sure they're helping you with conditions, making sure you determine whether or not the survey you have is worth anything. Is it a proper survey? Is there a survey available? If you're not sure about that, get the lawyer involved. Title insurance deals with some issues that we need. Make sure your clients are getting title insurance. We don't close any residential transactions in our office without title insurance. Can you close without it? Yes. Will we do it? No. Will some lawyers do it? Yes. My suggestion, that's not the lawyer that's going to protect your client on a residential transaction. Okay. Get proper coverage. Status certificates, they have to be reviewed and reviewed thoroughly. We charge a fee for reviewing it. Most lawyers out there, if they're not charging a fee, we're experiencing they're not doing a good job. They're not spending the time necessary to review a status certificate properly. Okay, make sure you're getting proper support. Make sure they're holding your hand through these processes, especially when deals go off the rails. That's when you need the lawyer the most. Okay, and that's when you need the good agent the most, and that's when you need the good mortgage broker the most. And that's the market that we're in today. Okay, where there is the potential of any deal going off the rails. So how do we deal with it? So that's why we want to be prepared. We want to anticipate these issues. We want to have the proper team in place. We want to take steps to avoid those issues by being proactive. So that's the bottom line message I could give you for today. Now, the good news, it's not the majority of transactions. It's not every transaction. It's still a minor percentage of transactions, but it's way more than it was in the spring. And this trend might continue for the foreseeable future because of all those factors that I discussed at the beginning. We're in that type of market. There's pressures on people. There's uncertainty in the market. So we're going to be going through this for a period of time. Maybe it's the next 6 months, maybe till we get to the spring market. You're going to be having these conversations with clients. We certainly are, even on transactions where there's nothing going on. So at least you know. And then when something does happen, you're prepared. So let's try and avoid these and get proper coverage and protect our clients and protect yourselves and your reputations. Okay, because if you're the guy, the agent on these transactions and helping them navigate through these tough situations, it's a no-brainer for you to get referrals. from their family and friends and everybody. Oh, I had such a problem in my transaction, and my agent so-and-so, they helped me through it, and my lawyer, David, or his office was fabulous, and blah, blah, blah. So you get the retainer, you get the referrals, we get the referrals from doing a good job and helping people navigate through tough times, okay? Anybody can close routine things, whether you're an agent or a lawyer. It's when things are more difficult, who's able to deal with it and step up. So I encourage you guys to be those agents and get your clients protected. So I'm prepared to stay on as long as you want to answer any questions. Hit
We have
me
a few here.
or contact me separately, whatever you prefer.
So this is where we find out who the good lawyers are, who the good mortgage brokers are, and who the good realtors are. When it gets tough. Okay, so one question here. Any idea on the expected cost of litigation? Are there lawyers who offer fixed cost litigation irrespective of the duration?
Yeah, there might be some that'll try and fix it to a certain amount. I would encourage you to, check them out, because I'm just always skeptical a little bit when someone's prepared to do that, because there's, in anything that's going to litigation, there's going to be some uncertainty to it. So a lawyer that's generally going to commit to a certain fixed amount is trying to just buy some business because they're not that busy. And I look at the same way, we do with, we compare ourselves with other transactional real estate lawyers. And for transactions, we do quote on a fixed basis on transactions, but we look at each transaction and try and figure out what it's going to be. But there's always a bunch of lawyers out there that are undercutting the market. Okay. And we know what our rates are. And I know our rates are really competitive with other real estate firms that are similar to ours that do a good job and a thorough job and have good personnel, and they got to pay everybody, good salaries because they're good people and they're doing a proper job. There's a whole bunch of lawyers out there that keep undercutting the market because they're not earning the business, and they're trying to buy the business. So they say, "Oh, you're going to use kormans? I'll charge you $100 less if you come to me." Okay, and I look at litigation lawyers the same way. So if someone is not standing up to protect what they should properly be paid to provide good legal services and protect their clients, and they're saying, I'm prepared to take a bath on this or take a haircut on this because I'm not that busy, so I'd rather do this for less money than not have the business. I'm a little concerned, because if I'm trying to recover my money on a transaction that better, I want a barracuda litigation lawyer.
Not somebody who's doing it for exposure.
Yeah, I want the best guy. I want a guy who's going to get me my money back. And yeah, that guy might be a little more expensive. So as long as it's reasonable, I want that guy. And hopefully some of those costs will be recovered from the defaulting buyer in any event. So I'm going to put up my retainer and hope I'm going to recover it. But I like my chances of recovering it all better from the barracuda lawyer than from the guy that's just to take me on and because he's looking for business.
Exactly. Okay, question here, which may be answered now because this was asked during the call, but when the seller is not willing to negotiate and they're not responding to any offer of negotiation, what should the buyer do?
Well, the buyer doesn't really have much legal remedy at that point. Okay. But all of the attempts to negotiate should be documented. Okay, by the lawyer, the agent, all the text communications, all the emails, letters, whatever the method of communication is, and everything should, and if there's a phone call, the phone call should be followed up with a confirming letter or email or something, because all of that might ultimately be material down the road, because the seller's not cooperating to negotiate something, they're standing under strict legal principles and they're going to sell to somebody else. But at some point in time, they're going to come back to make a claim for damages against that buyer. So all of those attempts to negotiate are defenses that the buyer might be able to build up to say, hey, the seller wasn't acting reasonably, the seller wasn't acting in good faith. We made all these reasonable offers to them and tried to keep them whole so they wouldn't lose any money, and they were just dismissing them and not responding. And a judge sees all that, they might find favorable in terms of the buyer to get them back some of their deposit money. And that's a situation where a judge might say, hey, I don't want to give this seller any windfall. I'll cover them for the costs, but I want to give that windfall money all back to the buyer. The buyer made some really reasonable attempts to get this transaction closed or to cover the seller, and the seller was totally uncooperative and didn't act in good faith. So I think as a buyer, you still go through that process, and you try and document everything because you might need it down the road.
Okay, excellent. Tina has her hand up. Go ahead, Tina, unmute.
Hi, David. How are you?
Good, Tina.
Good.
How you doing?
Good to see you. I have a question. So this is regarding a legal duplex, but it is in M2 zone, which is like industrial zone. Regarding that, is if someone wants to renovate or do something with the property, do you know if there's any problems with it, or how does it go? Because the zoning is not residential.
Yeah, the zoning might not be residential, but sometimes in the zoning, it might permit some residential use, or it might grandfather residential use that was already there. So you'd have to take a hard look, and you might need a municipal lawyer to take a look at it, who has an expertise on zoning and zoning bylaws and what can be done, because there might be a way to do it, or they might have to go and apply for a variance or something to the zoning to permit that. And you have to be careful also, because if by doing a renovation, if it's a substantial renovation, sometimes it might be that there was a grandfathered residential use, but if you do this substantial renovation or change it to some extent, it may no longer be grandfathered. So they may have to consult with a lawyer that does municipal law and make sure they're doing that properly, or a municipal planner or someone like that. It might not be a lawyer. They might be able to consult with someone like that that's familiar with it and can help them through that process.
Okay, sounds good. Thank you.
Okay.
All right, Marco has a question.
Yeah, hey, David.
Marco.
Thanks. Great training here. Actually, I got two questions, but I'll start with the anticipatory breach point that you made. You talked about lawyers sort of making that point of contact. Do us as agents have to be careful what we say to anticipate a potential breach that might cause that ball rolling? So in case we think, what should we be careful about what we say and leave that to the lawyers?
Yes, that's a great point, Marco. You absolutely have to be careful what you say, and what you say verbally and what you put in a text or anything like that, because all of that can be evidence at some point in time about the negotiations. Okay, so when the lawyer gets involved, and when I get involved in dealing with those type of negotiations, part of the correspondence, I'm always saying, without prejudice to our rights, we're prepared to do A, B, or consider doing A, B, C, and D. Okay. And we're using that type of phrase all the time because we want to be able to stand on our legal principles and our legal rights without giving it away in a negotiation. So the same thing for you as an agent. You really got to be careful. And that's why I encourage you to get the lawyers involved when things come to that point. So you're never committing to anything on behalf of your client. And I do that even internally in our office too. Like if we're on the buyer side, and we think we may not be able to get our financing in time and we might be defaulting and we're a week before closing, then what I'd be writing to the other lawyer is, like, I'm really reluctant to say, we're not gonna be able to close on October 13th. We can't get our financing. I'll usually say, we might not be able to close. Okay, we're trying, we still got a week. We're trying to get there. We might not be able to close. So, and we're just giving you a heads up, but we might not be able to close. So if we can't close, is the seller prepared to give us an extension? Because we think if we get an extra 2 days or we get an extra week, whatever it is, then we think we'll be able to close. But I want to put the word might in there. Okay, so they can't write me back and say, hey, you told us you can't close. That's an anticipatory breach. We're selling to somebody else. We're terminating you. So we're very careful about the language that we use. Okay. Because I'm on the other side. As soon as a lawyer says to me, hey, we can't get our financing, can't close on the 13th, I'm immediately writing it back saying, you're in breach. Yeah, that's an anticipatory breach. We're terminating you, blah, blah, blah. and they're reserving our rights. Now, I'll still talk to them and still try and negotiate something on a without prejudice basis, because it still might be better for us to try and close with them.
Mhm.
You know, and it's always worth trying to close with them than before you completely terminate them. But your point is, Marco, we have to be careful with our language, and anything an agent says can come back to haunt an innocent
Exactly.
seller too.
Perfect. Now, another question on the requisition date. You know, and we're always, and agents, it's so important. Once the deal is done, you know, submit those paperwork, send those paperwork right away. You know, don't leave it to the last minute. But under requisition, David, can you give us an explanation of what's the worst case scenario for requisition date is? You know, if we miss that date, is it just, you know, the requisition cost goes to the buyer? What are the ultimate risks in that? Just understanding that.
Okay. So let's say we had a transaction closing today and the requisition date was October 1st. Okay, but let's say the agreement was signed on July 1st. Okay, and that's what it was. We have until October 1st to search title and make any requisitions, and then we're closing on October 13th. So in our office, our practice is we get the offer in, the signed agreement in July 1st, it was sent to us, firm deal. We don't wait till October 1st to search title. We usually search title as soon as we get it in. And the reason we do that is because if we do find a title problem, we want to give the seller's lawyer time to clean it up and fix it. So we want to give them as much time as possible, fix it by October 13th. If I wait till October 1st, send it to them, now I've sent it on time, okay, and we have a title problem, now he's only got 12 days to fix it. He may not be able to fix it on time, okay? So we don't want to wait. Now, if we miss that October 1st date, and we send it to him on October 2nd or anytime after his date, his answer back is, you missed the time. Time was of the essence. You didn't get it to us by October 1st, and they don't have to do anything. They don't have to fix title. So the buyer has to now close the transaction and take whatever warts and defects are that goes along with that title, because we missed the time for requisitioning it. Okay. So if we requisitioned it on time, but the sellers can't fix it by the closing date, we're going to have to negotiate something, because maybe we can still close and the seller's lawyer will still fix the problem after closing, if that's a possibility. Or maybe we have to extend to give them a little more time to fix the problem, because we can't close until we fix the problem. But in any event, I encourage you as an agent, as soon as you have an agreement signed, send it to, get the lawyer, find out who the lawyer is, send it to the lawyer right away. And if those lawyers aren't doing what we do, then you're referring it to the wrong lawyer. Okay. And I talk to other lawyers about this all the time. There's no point in standing on your legal principles. Oh, I requisitioned to you October 1st, but I know it's going to take you 3 months to fix the title. And I've known about it for 3 months already. And so we're within our strict legal right. You have to fix title. But now we're in a situation where they can't close. How's that good for my buyer? Okay. So that's why we have in our practice, we want to search title as soon as possible so they can fix the title problem.
One more question. Sorry, I get these questions a lot from agents. So, you know, we talked about potential vendor takebacks to try to save a deal.
Yeah.
Anything to do with, you know, whether it's a first or a second or VTB, whatever we have from the seller, those ratios go on the buyers. So a lot of times these buyers can't, even if that opportunity, the seller wanted to help, you know, the buyer can't take on that responsibility on the ratios, and it would affect their current situation with their mortgage. Now, other than that option and other than the reducing of the price, is there a way where there might be either a promissory note or something between the seller and the buyer that won't affect the buyer's ratio, but still hold them responsible and maybe, you know, paying out that potential $50,000 reduction, or there's just no way around it?
Yeah, I think the short answer is there isn't really a way around that, because even if they're taking a promissory note, okay, like let's say they're $50,000 short, and the seller says, okay, you know, let's close the transaction, and that 50,000, you'll give me a promissory note and you'll pay me back in a month. Okay, that has to show up on the agreement of purchase and sale. Okay, it still shows in the agreement purchase sale. It was $1 million purchase price. There was a $100,000 deposit. And we're not, it's going to show we're not getting 900,000 on closing. We're going to show we're getting 850 on closing, and we're getting $50,000 by way of a promissory note. So that's still going to show up on a statement of adjustments. That statement of adjustments still has to go to a lender that's providing the first mortgage finance. The lender may not close on that basis. Okay, because all a promissory note is, it's no different than having a vendor take back mortgage. A vendor payment is still a promise by the buyer to pay them that $50,000. The difference is if it's a promissory note is unsecured, and a mortgage is still a promise to pay the $50,000, but it's secured by registering the mortgage on title. So if they don't pay that $50,000 back, the seller can ultimately sell the property to get their $50,000 because they've got the property as security. Okay, if it's just a promissory note, the seller doesn't have the right to sell the property to get paid back on the promissory note. They have to just sue on the promissory note and then try and recover on their judgment. So I think at the end of the day, it's still problematic, and lenders are going to find it problematic because that has to be disclosed to them, and they're going to see that the money's not all going to be paid. Now, if they say we're accepting that and go ahead and close and we'll advance funds, then great. But then you've still got a seller that's got a promissory note, but there's no security for that. So that might be acceptable to them. That might be a way to go, because they're taking a risk just with the $50,000, but at least they get the rest of their transaction closed. And if the buyer defaults on that promissory note, they do have the right to sue them. And now they're suing them just for the $50,000 promissory note and not suing them for a whole transaction that didn't close. So in some circumstances, it's certainly worth considering as an option.
Thanks.
Great questions, Marco.
Okay, we have another question in the chat here that I think is more about assignments, David. And you can certainly say, let's talk about this when we talk about assignments. Can a buyer who purchased a pre-construction condo with the aim of assigning, but could not get it assigned and cannot close, walk away under the 10 days cooling off? Now, the way I understand it, you're not doing an assignment in those 10 days.
Yeah, if you were trying to do your assignment during that 10-day period and your assignment didn't happen, but that's not likely. That's not a likely scenario.
Yeah,
because,
it's usually you've got
on any assignment, you need the
that.
consent of the builder too, and the builder's not going to consent to assignment at the same time that that a buyer is buying directly from the builder and still under their 10-day cooling off period. So it's not likely to happen factually.
Yeah. So Edwin, I think that you need to make sure that you come to our assignment classes, which we have scheduled on the calendar.
Yes, and while we're talking that
topic.
yeah, we just arranged, Dawn and I just booked a whole series of these webinars that we're doing. They're more or less every other week at Thursdays in this time slot. They're not all exactly that. We have to move a couple around, and we might shift a few more, but we're certainly going to be talking about assignments as part of that, and a bunch of other topics. And if any of you have any good suggestions for topics that you want covered, get in touch with Dawn or me, and we can certainly, try and accommodate those as well. The next one, I don't have access to my calendar right now, but it's
descriptions next week.
Next week. Okay.
Yeah. So legal descriptions is next Thursday at 12.
Okay.
Anybody have any other questions? Going once? Going twice? Oh, there's Edwin.
Oh, Edwin's got his hand up.
Edwin. Go ahead and unmute, Edwin. You can speak.
Thanks so much, David. Thanks, Dawn. I'll join the reassignment class. My question is, if an appraiser for a pre-construction property drops below the market price at the time of closing, does the buyer have the right to negotiate back with the builder, or what would the buyer do in this situation?
Okay, the great question, Edwin. The short answer is the buyer does not have a right to, get out of their transaction, unless they've had a really specific condition clause in there that gives them that right, to get out. But I've never seen that given yet. So the answer is they don't have a right to get out. You know, can they try and negotiate something with the builder? If you would ask me that question last spring, I'd say, you know, the builder's not interested in having any of those discussions. You know, the builders are softening a little bit in their position right now and trying to work with buyers a little more, knowing what's going on out there and knowing that it's not so easy if they default a buyer and just put it back. It's a process they don't want to go through on the market right now too, and it might take time to sell it. But there's no legal rights to any of that. It's certainly something that we go back and try and negotiate or see if there's something we can do.
David, I
with the
think we just
builder.
found a new topic. I just think we've just found a new topic because going this way, and also what's the name of that project in Barrie? If anybody knows, jump in and tell me. But the one that's been delayed and delayed and delayed by years. Now the builder's trying to come back to all the purchasers and say, we want another $140,000 from you because your property is worth that much more, even though you haven't taken possession of it yet. I think this is a good topic.
Yeah. So anyways, just to finish the answer, Edwin, it's a bit of a moving target with builders, and on every builder is establishing policies, and they're changing their policies too, how they're going to deal with the situation in the current market, and what they would decide today and what they'll decide 2 months from now might be two different things, because the market might come back. You know, but last spring these situations came up, and the year before that, and the builders weren't hesitating to default buyers because they had no problem selling their inventory to somebody else, and they would sell it at a higher price. Now they're going to be selling it a lot of times at a lower price, and they'll do the same thing, reserve the right for damages, etc. But you know, they don't want to go through that process if there's something reasonable that could be negotiated. So if they have to give a buyer a little rope, give them a little more time to get a transaction closed, and they can get their costs covered, a lot of them are prepared to discuss that right now.
David, on your, you know, when you on the conditional period with, you know, the 10-day grace on new condo construction, how involved does your firm get on the concessions of, like, you know, trying to cap rates and negotiating with the other lawyers? Is it the agent does it themselves, or do you guys help with that? Because I kind of seen two sides of that world where it's like we make these recommendations and go ahead and try it, and the realtor needs to do that versus the lawyers.
Yeah, I think it's something that really should be thrown to the lawyer to do. You know, there's a lot of issues in agreement purchase sale that we have to review and go through. So I think every new construction agreement purchase sale should be reviewed by a lawyer. Now, having said that, there's a role for the agents too, because a lot of times the agents can find out from the sales office, like, what type of concessions they're agreeing to, you know, what type of caps are they generally agreeing to up front. Now, that doesn't mean we might say, okay, here's the caps that they agreed to last week. So to me, that's a starting point. I would ask for all of those, but a lot of times we're asking for more in addition to that. And so we send out a letter to the builder's lawyer saying, hey, we reviewed the agreement. Here's costs. We want certain costs deleted. We want other things capped. And then we'll see what they say. And they might say no to everything, or they might give us what they gave everybody last week and that the agent was able to find out. Or maybe we're going to get more because the market changed in the last few days. And last week they had a lineup of people, and today they got no lineup. So maybe we get more. So I never want to under ask for certain things, because if you don't ask, you don't get. But if you ask and they say no, at least you tried.
So at least it's good that you guys help with that process too.
That's part of the process. The lawyers should be doing it. The lawyers should be reviewing the agreement purchase sale and sending a letter to the builder's lawyer requesting those type of changes. Now, you as an agent, if you can get certain things capped, and that's done as an amendment, and that's part of the original deal before the lawyer even reviews it, that's great.
Right.
Because that gives us that starting point, but we're still going to review it, and we're still going to ask for more.
Of course. Good. Yeah.
Anybody else? All right, well, I'm going to remind you all that we have a 2 o'clock session today. It's our pre-construction time slot that we're going to be discussing garden and laneway suites. Marco, do you have anything you want to add on that?
Yeah, no, it's just Yeah, it's exciting new sort of way, because I know with Leading Edge, we've been doing a lot of new construction and we've been doing resales. This is sort of a different avenue of considering. So these are potential clients that you may have that already have a home in certain qualified municipalities that allow, with certain permits in place, but allow them to build a suite, whether a garden or a laneway, and potentially rent it out for extra, income, rental income, or rent out to their family or parents. So it's a great opportunity. We're working with this builder, and they are offering a referral of $10,000 to agents. So just another path for us to sell on. I know David Korman will be present, at least kind of probably asking some questions. And, I kind of ahead of time sent the APS from this builder to David and some of the information and the contacts. So I'm happy that David's starting with us from the beginning on a new venture. So definitely, guys, I recommend stay there, show up 2 o'clock, and let's see where it goes.
Awesome. Thank you, Marco. And with that, I'll shut this one down and see everybody at 2 o'clock. Have a great day.